Hello friends, in the series on the income tax cases, today we will discuss an issue which is based on section 148 notices and the difference of the alleged income escaping amounts in section 148A clause B show cause notice and subsequently passed order under section 148A clause D order. It has become a general practice of the Revenue Department that when they issue the notice under section 148A clause B, they allege some amount which has escaped assessment, and ultimately when they issue the notice under section 148 along with section 148A clause D order, then they come up with some another amount. And more interestingly, when these different figures are there in the various notices of the revenue, they are even being sanctioned by their approving authorities without any comments. Basically, there should be application of mind to the material on the basis of which the reopening of assessment is done. This is the general concept. This is the general law for issuing the notices under section 148. And we have seen that there is generally the discrepancy in the quantum of escapement of income which is alleged in section 148A clause B notices and ultimately the order under section 148A clause D. So what should be the fate of these type of notices and whether they pass the jurisdictional requirement of issuing the notice under section 148? This issue has been taken by the Honorable Bombay High Court in the case of Vodafone India Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 464 ITR at page number 385. The date of the judgment is 19th March 2024. The case is very latest. In the present case, when the notice was issued under section 148A clause B, there was some amount A which the assessing officer was alleging that this has escaped assessment. The assessee submitted his submissions, and when the revenue came out with the notice under section 148 along with the order under section 148A clause D, then they reduced that amount of the income escaping assessment. The assessee challenged this notice on the ground that the revenue didn't have the material on the basis of which the reopening was done, and it is a case of just collecting the information from the assessee, and the notice under section 148 along with order under section 148A clause D has been passed without application of mind by the approving authority. When this matter was heard by the Bombay High Court quashed the notice under section 148 by saying that this difference which was alleged for the escapement of income was not noticed by the concerned sanctioning authority, and there was complete application of mind by the sanctioning authority in issuing the order under section 148A clause D. The Bombay High Court said that if the authorities have read the record carefully, then they have not issued the notice under section 148 because the amount of alleged income escaping assessment is different in both the notices, that is notice under section 148A clause B and the order under section 148A clause D. The Bombay High Court also ordered to send the copy of the order of this writ petition to the Revenue Secretary so that the casual behavior of the officer can be stopped and the notices should not be issued in such a casual manner. Friends, the importance of this case becomes because it is seen that the amount which is mentioned in the show cause notices under section 148A clause B is sometimes less, and then that amount is increased at the time of order under section 148A clause D. But in this case, the case was the reverse. The amount was reduced, and even then the Bombay High Court said that there was no application of mind by the approving authority. So friends, the crux of the case is that, as on date also, that in issuing the notices under section 148, the revenue should apply his mind at the time of issue of show cause notice under section 148A clause B, that what is the amount of income escaping assessment. They cannot play with this amount. They cannot change this amount. The whole crux of the case is that if the change in the amount of the income escaping assessment in the different notices is there, then it means that the notices are issued in a casual manner. At the end of this deliberation, I am repeating the name of the case. The name of the case is Vodafone India Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 464 ITR at page number 385, and the matter has been decided by Bombay High Court, and the date of the judgment is 19th March 2024. Thank you, friends.